Welcome to this dramatic and informative presentation of the Lake Malawi dispute between Malawi and Tanzania. As concerned citizen of the Republic of Malawi, we are eager to explore the intricacies of this long-standing issue. This dispute is not just about territorial claims, but also about the historical, cultural, and economic significance of Lake Malawi to our nation. As we delve into the world of international law, diplomacy, and regional politics, we will examine the roots of the dispute, which date back to the 1890 Helgoland-Zanzibar Treaty between Great Britain and Imperial Germany. This treaty established the boundary between Malawi and Tanzania, but its interpretation has been a subject of contention for decades. Throughout this presentation, we will follow the dramatic twists and turns of the dispute, from the initial claims and counterclaims to the attempts of mediation and arbitration. We will also explore the economic and environmental implications of the dispute, including the potential for oil and gas exploration in the lake. As Malawians, we are committed to uphold the principle of justice, sovereignty, and territorial integrity. We believe that the dispute should be resolved through peaceful means, taking into account the historical and legal facts, as well as the interest of our nation and its people. So let's embark on this journey of discovery as we explore the complex and fascinating world of the Lake Malawi dispute.
All rise.
Get seated. Honorable members of the International Court of Justice, esteemed representative of Malawi and Tanzania, and members of the place, I, Charles Soker, Chief Justice, welcome you to these historical proceedings. As we convene today, I would like to take a moment to outline the framework for our deliberations. In the interest of transparency and accountability, this court will permit full media coverage of these proceedings, ensuring that the global community remains informed of our progress. Regarding the presentation of arguments, I here grant counsel for Malawi 5 consecutive days to present their case, ensuring that all pertinent facts and arguments are thoroughly examined. Let me emphasize that the court will carefully consider all submissions and evidence presented by both parties. And after thorough deliberations, we will render our judgment, which will be final and binding on both parties. I urge both parties to approach these proceedings with respect, dignity, commitment to the principles of international law. Let us work together to ensure that justice is served and that the rights and interests of all parties are protected. With these introductory remarks, I declare these proceedings open. Counsel for Malawi, you may proceed with your opening statement. Your Honor, esteemed judges of the International Court of Justice, I stand before you today as a counsel for the government of Malawi. We're here to resolve a long-standing dispute with the government of Tanzania regarding the boundary of Lake Malawi. As stated in the 1890 Anglo-German Treaty, the boundary between Malawi and Tanzania is clearly defined as the shoreline of Lake Malawi. This treaty has been the foundation of our claim to sovereignty over the lake. However, the government of Tanzania has chosen to disregard this treaty and instead claims that the boundary should be the median line of the lake. We strongly disagree with this assertion, as it has no basis in international law or historical precedent. Furthermore, Tanzania's action in upgrading the Mbaba Bay port without consulting Malawi are a clear violation of our sovereignty and territorial integrity. We argue the court to take into account the economical and environmental implications of Tanzania's actions and to rule in favor of Malawi's sovereignty over the lake. Rebuttal to Tanzania's argument. Counsel for Tanzania may argue that the median line principle should apply, but this argument is flawed. The The median line principle is only applicable in cases where there is no established boundary, which is not the case here. Moreover, Tanzania claims that the boundary should be the median line of the lake is a recent development, and it is clear that this claim is motivated by the discovery of oil and gas reserves in the lake. We argue the court to reject this opportunistic claim and to uphold the established boundary and defined in the 1890 Anglo-Germany Treaty. In conclusion, Your Honor, we argue the International Court of Justice to rule in favor of Malawi's sovereignty over Lake Malawi. We believe that the evidence and international law are clear on our side, and we look forward to the court's decision. This concludes the proceedings for today. I would like to thank Counsel for Malawi for their comprehensive presentation. This court will reconvene tomorrow at 10 a.m. sharp, at which time Counsel for Tanzania will begin their presentation. I remind both parties that the court expects all submissions and evidence to be presented in a timely and respectful manner. I also remind the media and the public that these proceedings are being conducted in accordance with the rules of the International Court of Justice. This court is adjourned until tomorrow, 10 a.m. I wish everyone a good evening.
All rise.
No, si vuoi piacere
All rise.
Get seated. This court is now in session. Yesterday, we heard the opening statement from Counsel for Malawi. Today, we will hear the presentation from the representative of Tanzania.
Thank you, Your Honor. Tanzania's position is clear. We have a legitimate claim to the disputed territory in Lake Malawi based on historical and geographical grounds.
Thank you, Tanzanian representative. Your presentation is now concluded. Counsel for Malawi, you may now proceed with your questions. Your Honor, esteemed members of the court, I would like to begin my questioning of the witness. Representative of Tanzania, can you please confirm your role in the government and your involvement in the Lake Malawi dispute?
I am the Minister of Fishing and Pisa, and I am here to talk about the lake and Pisa.
I would like to clarify, Representative, that Tanzania's claim to the lake is based on the median line principle. However, isn't it true that this principle is only applicable in cases where there is no established boundary?
Your Honor, I rise to object. The questions being posed by Counsel for Malawi are premature and assume the facts not in evidence. We cannot allow this line of questioning to continue.
I'm afraid that's not a valid objection at this time, Mr. Diesel. Counsel for Malawi has not yet even asked a question. It's too far error to object. Please, Counsel for Malawi, proceed with your questioning. But Your Honor, I have made my ruling, Mr. Diesel. Please do not interrupt the proceedings again. Counsel for Malawi, you may proceed.